Good afternoon, everyone. Thank you for joining us in part 2 of the restructuring set of lectures. We're going to start where we left off with a little laugh about how restructuring in Singapore and restructuring in UK is actually very different, though under the same banner of the name of restructuring, and how pre-packs in definition also are different. And one can think of no better person to do a hand-holding and a walkthrough for you than our speaker today, who's Sarah Patterson. And I'm particularly excited to introduce this speaker because this is the trajectory in life that I want to follow as a professor. And welcoming her to this platform at Jindal Global Law School for this particular public lecture series and its kickstart is a very exciting moment for me. Now, Sarah Patterson is an associate professor of law at the London School of Economics and Political Science, where she teaches and researches corporate insolvency and restructuring law. Of course, before joining LSE, Sarah was a partner in restructuring and insolvency at Slaughter & May, with whom she still retains a senior consultancy. Now, Sarah co-authors in many reputed journals, and also specifically the comparative US-UK corporate section of debt restructuring with Alan Kornberg. She edits McKnight, Patterson, and Zakrzewski. I've misspelled that name, Zakrzewski, on the law of international finance, and is the author of the new monograph, which is going to become a part of my course manual shortly, which is the Corporate Reorganization Law and Forces of Change. And without further ado, I want to open up the floor for a lecture on the UK restructuring law and regime, and invite Sarah to take us through the lecture today.
Thank you, Ishana, and for such a warm and generous introduction. I'm completely delighted to be here. So let me just start by sharing my screen. I hope everyone can see that. So this is an ambitious undertaking. In 50 minutes, I'm hoping to walk through the development of English restructuring law from its modern origins, really in the 1980s, all the way through to the present day. So we're going to start with the rise and fall of what was known as the London approach. And I will explain what I mean by that in a moment. I hope that it will be particularly interesting for you for various reasons that will become clear. And then I'm going to divide the account of modern restructuring really into two buckets. First of all, small and medium-sized enterprises, for which we use two tools: the company voluntary arrangement, and perhaps more popularly, a version of prepackaged sales, which I've called connected party prepackaged administration sales. In the large corporate restructuring space, we use schemes of arrangement. We have used schemes together with or twinned with prepackaged administration sales, and I will explain why. And we have a brand new Part 26A restructuring procedure, which was introduced by the Corporate Insolvency and Governance Act 2020. So first of all, I'm going to start with the rise and then the fall of what is known as the London approach. So the first thing to understand is that in the 1980s, the organisational and institutional structure of the English finance market looked very different from its structure today. Crucially, most of our large corporates borrowed money through syndicated loans. So if you go back before the 1970s, typically large corporates borrowed from one or two large banks. And then the syndicated loan develops, and we have groups of banks lending money to large corporates, but they are banks. The lenders in that structure are banks. Predominantly large British banks, particularly what becomes known as the Big Four major banks in the UK, but also some major European banks. And the British banks and the European banks had close relationships with each other and relationship arrangements in place between them. And this is really crucial to this part of the story. why is it crucial? Well, the London approach was really a set of principles. It was initially promulgated in a speech by Kent, who was a director at the Bank of England. So in the 1970s, the Bank of England had experience of trying to agree out-of-court restructurings, broker them between banks and borrowers in a particular commercial property crisis, which we had in the UK. And they took their experience from that and decided to build it out into a more generalized set of principles around how banks should behave when their borrowers were in trouble. And this is really large corporates. So there were three main tenets to the London approach. First of all, that banks should remain supportive of their borrowers. Secondly, that borrowers should make sure banks had reliable information. And crucially, the banks should work together to reach a collective view on whether and how a company should be reorganized. And Kent, who, as I've said, is really central to the development of the London approach, published a really nice summary of it in a Bank of England quarterly bulletin in 1993, which is still available. You can Google it. And this process was confidential. So I started in practice in the era of the London approach, and we negotiated these deals with the bank and the borrower around the table, over many nights in the office. But crucially, the idea was that it was confidential. And I like this quote, which is from a Flood, Abbey, Skodarski and Aber paper. The whole process takes place outside the glare of publicity. One banker said the last thing he wanted to see was the unsecured creditors jumping out at the news. So what they specifically mean there are general unsecured creditors, the trade, the employees, and so on. The cloak of secrecy also helps the banks to work together rather than in competition with each other. So this was a highly cooperative process happening between closed doors and limited to the banks and the borrower. To the extent that we needed operational creditors, so general unsecured trade creditors, to the extent we needed them to agree a compromise, that was generally done bilaterally over the phone and in a fairly low-key way. And what were the principles? Well, the principles that underpinned the London approach, and again, they were principles and not rules, were that banks should refrain from enforcing while you tried to agree the restructuring. If new money was needed, it should go in on priority terms. There was an agreement on the date at which losses would be calculated. And the basic idea was that banks would then be kept in the position they were in relative to each other at the date at which those losses are set. But overall, and I can't emphasize this enough, it was underpinned by a very generalized idea of fairness. So this was not about standing on your strict legal rights. This was about agreeing a fair deal. And Armour and Deakin also have a very nice article, really actually at the tail end of the London approach as it really begins to lose its force, in which they note that typically you left 15% with the shareholders. Now, that wasn't because of any careful economic calculation that the right amount to leave the shareholders was about 15%. It was supposed to be not such a significant amount that the banks minded leaving it on the table, but significant enough to get the shareholders to come along with the deal. And these principles were just widely understood, but not really written down anywhere until they were published by the British Bankers Association in 1990. So how on earth were they enforced? Well, this is a really interesting story. First of all, as I've said, they are promulgated by the Bank of England. So the Bank of England develops these principles. Kent gives his speech. And at this point, the Bank of England is the regulator for the banks. So the banks understand that they have to comply with these principles because otherwise they will upset their regulator. And there are all sorts of stories about the Bank of England phoning lenders up and saying, we hear you're not behaving in a very cooperative way in this deal. We hear you're not observing our basic principles of fairness. Please pop round for a cup of tea at Threadneedle Street, which is where the Bank of England is located. And that was seen as enough to get the banks to fall into line. We have no idea whether those phone calls happened or not, or whether they're apocryphal, but there are plenty of stories circulated about them in the market. But I also can't emphasize enough what soft power the Bank of England exerted at this time. It isn't just that they are the regulator, they also exert considerable soft power. We don't have time to go through this today, but there was an extremely close and respectful relationship that goes beyond really a regulatory function between the Bank of England and the British banks during this period. The British banks benefited from an extremely nice environment, really, in which they could set interest rates together and hold them at that rate, at which they had all sorts of latitude to dominate the market. And the Bank of England largely accepted that, but the quid pro quo for that was you would also observe what the Bank of England wanted you to do. So the Bank of England exerted considerable soft power in making sure these principles were enforced. And the image that comes up time and time again in the literature is the governor's eyebrows. In other words, the only thing that the Bank of England governor needed to do was raise his eyebrows to a bank to cause the bank to fall into line. And then this environment changes, and it changes quite dramatically. The Bank of England loses its regulatory function. Actually, it gets it back much later in the story. But then the bank also begins to retreat as a matter of policy, because this relationship between the Bank of England and the banks begins to change very profoundly. So monetarism comes in the UK, controlling the economy through interest rates and the money supply, rather than through these soft, informal, cooperative relationships between banks and the Bank of England. So the environment changes profoundly. Now, for a while, the London approach doesn't lose its force. And it doesn't lose its force because this was an era of, as I've said, the syndicated loan market, in which banks primarily relied on playing in that market to make profit. So this is an era in which they are still making money by lending cash, collecting interest and being repaid at maturity. And they are, of course, repeat players. They need to keep participating in this syndicated loan market. And there was a concern that if you behaved badly during a restructuring deal, and by this I mean that you did not observe these principles that were set out in the London approach, then you would be excluded from this syndicated loan market. In other words, the next time a bank was putting together a syndicate and ringing round to ask people to participate, you would not receive the call, because you were seen to have not played by the rules of the game when one of these loans ran into trouble. And that caused cost and bother for everybody else. And so for a while, even when the Bank of England stops enforcing these deals and really steps back, for a while, the London approach principles continue to work. And they work because this is a tight loan market dominated by the same banks who are repeat players. And there is market power to exclude them from deals if they're not seen to have played by the rules of the game. But then everything changes, and it changes quickly, and it changes dramatically. And these are just some of the points I could have made about how dramatically the English finance market shifts from this world of a few large banks lending syndicated loans and also lending bilaterally to smaller companies. First of all, debt capital markets begin to become much more important in the UK. In the era I'm talking about, very few large corporates would have accessed the bond markets, and those that did would have been extraordinarily good credits. But the high yield bond, the innovation that Michael Milken brings in or develops in the US, where some investment grade borrowers are able to access bond markets, that begins to appear in the UK. I'm not sure that is as important, though, as the rise of the distressed debt investors in the UK. So beginning with the restructuring of Barings Bank, investors who invest in distressed debt with a view to participating in some sort of profitable way in the restructuring transaction move their sights from the US, which is where they had primarily been located, and come into, in a big way, the UK market. And this is profound because these investors don't care at all if the threat is that they will be excluded from primary markets. from syndicated loan markets. They don't play in the primary market. And so the threat of exclusion from the relatively cozy world of large banks lending money doesn't have any force with these players. Even more profound is the changing providers of syndicated finance. So I'm sure that many of you have followed the originate to distribute model. So banks move from a world in which they make money simply by lending money, recovering on the interest rate and getting repaid at maturity, into a world in which they get paid for putting deals together, but they rapidly move to trading their debt, selling their loan participations. That does not become such an important part of the story. And of course, the recent and dramatic rise here has been the rise of the collateralized loan obligation, or CLO. So these are hugely significant now in large loans in the UK, in large leverage loans, so where the amount of money borrowed relative to earnings is very high, those loans are dominated by CLOs, or collateralized loan obligations. So a bank originates the loan and then sells it to a CLO. And again, these participants have a completely different organizational and institutional structure. They're buying in the secondary markets. They're not vulnerable to being excluded from a primary syndication. They're buying in volume. I mean, we could do a session just on this, but their motivations are completely different. The market, of course, becomes global. So this idea that Britain has its own principles which it can enforce against the British banks, and which the British banks in turn can enforce against their respondent European banks, loses its force as the market explodes, becomes a global market. And all of this means that the London approach really stops working. A world of a set of principles which are enforced as basically social norms between a few large players stops working. It loses its force. And so out of court restructuring for large companies becomes much harder to do these deals in the way I would have done them when I started in the early 90s, where the syndicate or the representatives of the syndicate and the borrower got in a room and hashed out a deal. And these new players won't leave 15% with the shareholders because that's how it's done. They don't view it as, well, that's enough to keep the shareholders happy and we don't really worry about 15%. They don't, their economic calculus is completely different. And indeed, I think they would be extremely critical of that world, which they would see as cozy and gentlemanly and uncompetitive, and not a world to be admired at all. And so once again, it becomes much harder to deal with holdout power. It becomes much harder to persuade everybody to come to the table. And so what we need is much more resort to legal procedure. Now, this also happens for slightly different reasons, but this also happens at the smaller end of the market. So at the small and medium-sized enterprise end of the market. So before the collapse of the London approach, we wouldn't have used London approach principles to agree an out-of-court restructuring with a small company. But the same basic idea applied, that the bank would try to do a bilateral deal, or at least leave the small company with a long period of time in which to recover. And then if that didn't work out in the end, the bank would probably enforce. There is a growing recognition that parallels this rise of modern finance. There's a growing recognition that actually small companies may need to restructure their liabilities. Just giving them a very long period of time in which to try to recover might give rise to the popular zombie period, zombie company problem. So the small company can't raise more debt. It's got too much debt on its balance sheet. It has no money to invest in its business. And it just struggles on, but actually has no real opportunity to get back on its feet. And so there's a growing recognition, really running in parallel with this changing nature of our finance market, that we need tools to proactively help small companies to restructure. So we have two tools, and the first is the company voluntary arrangement. The company voluntary arrangement was an innovation from our Cork committee, which reports at the beginning of the 1980s, and which remains an incredibly important document in the UK. It was an extraordinarily impressive review of the state of corporate insolvency at that point in time. And the court committee specifically saw the need for small companies, small and medium-sized companies, to have a simple debt restructuring tool. They recognize the fact that SMEs may not be able to just trade out of their difficulties. They may actually need to restructure their liabilities. So the company voluntary arrangement was deliberately designed for this. And this chart just takes us through the steps. I'm going to do this relatively quickly. So we start on the left-hand side with preparation. And we begin by talking to our creditors about what kind of restructuring we may do. I've said we talk to secured creditors, and that's because we need them on side, but you can't actually compromise secured debt in a company voluntary arrangement without the secured creditor's consent. Now, I'm going to talk about that a little bit more in a moment when I talk about the fact that practically, normally in the UK, if your bank is not on side and you're a small and medium-sized company, you won't be able to do your restructuring deal anyway. The vast majority of SMEs in the UK, to the extent they have external financing, still rely on a bank. The proposals are drafted and what is called a nominee is appointed. So this is an insolvency practitioner. And the legislation provides that the nominee considers the director's proposals and has 28 days to report to court about whether the creditor's decision on the proposal should be sought. Now, of course, in reality, the insolvency practitioner doesn't wait for the directors to come up with the plan and then reads it. I mean, in reality, it is the insolvency practitioner which will help the directors to craft the plan. And a typical company voluntary arrangement would be, we're going to offer a certain amount for all of our pre-company voluntary arrangement debts. So let's say we're going to offer 8 pence in every British pound for liabilities which are outstanding at the date of the company voluntary arrangement. And then we're going to have a period of time, let's say 3 to 5 years, in which we can pay that amount out of our profits. And then we'll probably do some contractual restructuring and other restructuring in the agreement. So the idea is that we get back on our feet, we suspend our obligation to pay our pre-filing liability, we compromise how much we've got to pay, and we give ourselves time to pay it. Who votes? Well, the shareholders, that's the members vote. More than 50% of voting members by value have to support the plan. However, if they don't, but the creditors do, then the creditors' vote prevails, although the members can complain to the court. In terms of the creditors' decision-making process, this was intended as a very simple process for small companies. So the court committee explicitly says that that's how it was conceived. And so creditors vote as a single class. We don't split creditors into classes for the purposes of voting. You need more than 75% of voting creditors, so those creditors who turn up to the vote, by value, but more than 50% of those creditors must be unconnected. I'm not going to go through the concept of connected, which is pretty complex in our Act, but it is, for all intents and purposes, what you would expect. So not directors, not companies associated with the company, not companies where the director is also a director of that company, and so on. And of course, the idea here is to ensure that those connected creditors who may have particular reasons for pushing the plan through are not the people who have achieved the success of the vote. So the court wants to see that those creditors who were unconnected with the plan thought this was a good plan, a plan they should support. And very crucially, contingent creditors vote for a minimum of £1 unless the chairman or the nominee agrees higher value. And I'm going to touch on that just very briefly in one moment. There's then a 28-day initial challenge period after this has happened. So the court has no active involvement in this process. There are reports to the court, but those are made on paper. And there will be no court hearing at all unless the creditors challenge the company voluntary arrangement. If they do, they can challenge it on one of two grounds within this 28-day period. Firstly, that the company voluntary arrangement is unfairly prejudicial. And very broadly, that requires a consideration of two things. Firstly, are the creditors worse off as a result of the company voluntary arrangement than they would have been if the company had simply been put into an insolvency process and its business and assets sold, or its assets sold? And secondly, are one group of creditors of an equal rank with another treated in a way which is more prejudicial? So is that unfair? And it must be unfair. It's not just that they are treated differently, it is that differential treatment is unfair. And the second ground is material irregularity, which is again what you would expect. Has something gone wrong in the way the meeting was put together? Has the chairman done something which the creditors object to? Now, challenges have been comparatively rare, although we are seeing many more at the moment, because we've got a particular adaptation of this, which I don't have time to talk about today, where some very large companies have adapted this process solely to deal with rental liabilities. So in the UK at the moment, we have something of a crisis in our hospitality, casual dining and retail industries. So shoppers shopping online, our casual dining industry, which in the UK means things like pizzas and burgers, has become very competitive, a great deal of competition for consumers' money. And of course, this has all been compounded by our successive lockdowns in the COVID-19 pandemic. So there has been a particular adaptation of this procedure, which some very large companies have used in a way which it was also almost certainly not intended for, to try to address rental liabilities in these sorts of businesses. We are seeing a number of challenges coming before the courts to those deals at the moment. Assuming, though, that we either survive the challenge after a 28-day challenge period, or more usually there is no challenge, the CVA then remains effective unless either a creditor who did not have notice of the original decision-making process launches some sort of challenge. So a creditor who was not notified of the vote on the company voluntary arrangement is bound by it. So they are bound by the compromise, but their right to challenge the company voluntary arrangement arises 28 days after they become aware that the decision happened. Secondly, and more commonly, company voluntary arrangements very frequently fail. And we've got recent empirical evidence that shows this. So we have, for example, promised that we will pay 8 pence in every British pound for those pre-filing liabilities over 3 years. But in fact, we just never make enough money to make those payments under the company voluntary arrangement. And the company voluntary arrangement fails and the company has to be put into an insolvency process. And empirical evidence suggests that that is actually a reasonably frequent occurrence. Now, the company voluntary arrangement is not nearly as popular. In fact, it's not nearly as regularly used by small and medium-sized companies as an adaptation of the pre-packaged sale in order to achieve a restructuring. So this requires a little bit of unpacking. Administration is our principal insolvency procedure, used most regularly to achieve a sale of the business and assets as a going concern. So that is where it is most commonly used in the market. In a pre-packaged administration sale, that sale of the business and assets is negotiated with a purchaser before the company is put into administration. The company is then put into administration, an insolvency practitioner is appointed, and the sale is immediately implemented, very rapidly implemented. And of course, you will instantly see, in common with pre-packaged deals around the world, that the idea here is that once the creditors realize that the company is put into a process, so that's the bad news story, there is an immediate good news story of don't panic, we've achieved a rescue of the business and assets as a going concern. So the idea, of course, is to reduce both the direct costs, but also the indirect costs of an insolvency process. Indirect costs in terms of management distraction, but also in terms of suppliers becoming nervous about supplying the company, customers deserting the company, and so on. And so we got the vestiges really of the commitment in the London approach to trying to conclude things with a cloak of secrecy, a cloak of confidentiality. Now, the particular adaptation of this, which small companies use to achieve a restructuring, is what's called a connected party prepackaged administration. So in this, what we're basically doing is selling, and I've put that in quotes for reasons that I hope will become clear, we're selling the business and assets to a new company which is owned by the existing management team. So I am assuming for the purposes of this presentation that what we have are some owner managers. So we have directors of our distressed small and medium-sized company who are also the owners of the business, the shareholders. So this would be very typical, for example, for a family-owned business in the UK. Those owner managers set up a new company and they own the shares in the new company. They then launch an auction process to sell the business and assets of the distressed debtor as a going concern. And they line up an administrator in waiting. And ordinarily, their bank is completely on side with this process for reasons which will become clear in a moment. So the auction happens, NewCo bids in the auction and typically wins. There is a great deal of controversy in the UK about whether these deals happen at an undervalue. And indeed, that is really where most of the regulatory attention has been. But in reality, I'm not convinced that that is right. I think very often that the owner managers are actually the only people who are interested in trying to rescue this business. They know it best. They often have a long run family commitment to it. It isn't that there is a fabulous market for these small businesses outside those owner managers and their commitment to a rescue. So in my own work, I have suggested in various pieces that really the controversy in this process lies somewhere else, which I hope we'll touch on. So the administrator is then appointed. It's possible to appoint an insolvency practitioner out of court in the UK. So once again, a typical connected party prepackaged administration sale will happen with no court hearing at all, unless somebody raises some sort of challenge and proactively starts a court case. The administrator then signs the sale and purchase agreement with NewCo in order to sell the business and assets of the company to NewCo. But here is the really crucial point. The NewCo will then effectively decide which liabilities to assume and which liabilities to leave behind. So in the business purchase agreement, NewCo will say which liabilities it's assuming and which it's leaving behind. Ransom suppliers are typically paid in full. So this is often actually pretty much all of the trade, not always. Sometimes, and there have been some high profile and very controversial cases in which particular trade creditors have had their liabilities assumed and particular ones have not. In many cases, it's pretty much all of the trade, but leaving behind, for example, landlords for unprofitable leases. And so those unsecured creditors whose liabilities are not assumed by NewCo are left behind in the now empty debtor company that has sold its business and assets in the pre-packaged sale. Now, why does the bank go along with this? Well, ordinarily, the bank will effectively round trip its money. What do I mean by that? Well, at this end of the market in the UK, banks are pretty much always secured. And that means that they rank higher in England's distributional order of priority in corporate insolvency than the general unsecured creditors. There are some preferential liabilities which will rank ahead of some of their security, and that's a complex question and for another day. There are also expenses of the case which will have priority, and we have something called the prescribed part, which is a relatively small amount which is deducted from part of the bank's security and paid to the unsecured creditors. And so those amounts will have to be funded. But other than that small amount of leakage, what happens is that the bank lends the money to NewCo to fund the purchase price. And that purchase price pays for these small amounts that have priority and have to be paid, but then is round tripped back to the bank as the secured creditor. So the secured creditor receives the distribution of the price as the secured creditor in the distributional order of priority. And so I hope what you will see is that the bank has basically rolled over its loan. So the bank is in the same position really that it was in before, probably with a little bit of leakage, but it hopes not too much. It is now the lender to the company, still owned by the directors and with the same business. But what it has done, it's left behind some of those unsecured liabilities that the company was struggling to pay. And so what we have is the pre-packaged administration sale being used as a restructuring procedure, a way of restructuring the liabilities. This is significantly more popular than the company voluntary arrangement, and I think you will see why. In the company voluntary arrangement, we have to get a vote of 75% of creditors voting in person. And we may have a large number of small creditors in a small company. And corralling those creditors and getting them to agree the plan can be extremely time consuming, and it can be difficult to stabilize the business while that negotiation is happening. At the same time, we're directors of a small and medium-sized company. We don't have an enormous amount of bandwidth to both be running a negotiation and running the business. And of course, what happens in many of these cases is exactly what you would expect to happen. The company starts out seeking, for example, to pay 8p in every British pound for pre-filing liabilities. But during the deal, it is bid up by the creditors. It ends up offering 14p in the British pound. It can't afford that, and the company voluntary arrangement collapses. The beauty of the pre-packaged administration sale, but also its controversy, is that I don't really have to engage with my unsecured creditors at all unless I think they're critical to my business. If I think they're critical to my business, I'm going to pay them in full anyway, and I'm going to take them across. If I think they're not critical, then I can attempt to do my pre-packaged administration under that cloak of secrecy that we talked about at the beginning, and avoid engaging with the creditors at all. At the moment at which I announce the deal, I'm announcing that the business has been saved. The critical creditors are happy anyway because they are preserved in the deal. And at that point, there is very little that those creditors who have been abandoned in the now empty debtor company can do. There's very little they can do to challenge the transaction. Now, as I've said, these are hugely controversial in Britain. And there have been many reform efforts, many consultations on reform. We have some new regulations coming in now. The regulatory focus, as I said, has tended to be on whether these are at an undervalue. My own view is that I don't really think that is the problem. I think the problem is that the administrator, the directors, and to a certain extent the bank, pick and choose who goes across, whose liability is assumed and who are not, in a way which is not transparent at all until afterwards. And so as a creditor, I may be trading with this company completely unaware that the pre-packaged administration sale is in contemplation, while the insiders are completely aware that it's in contemplation. And I'm not sure that that controversy can ever be dealt with other than by making the disclosure more significant and by requiring greater participation. But of course, that would completely undermine the utility of these as a restructuring tool. These are a very effective SME tool because I would suggest that SMEs always need a way to impose a non-negotiated plan because they have so little cash with which to run a complex and expensive process. And so these are an effective restructuring tool. But the very things that make them effective, that lack of transparency, the ability to complete the deal under the cloak of secrecy, the ability to do the deal out of court, the very things which give this procedure its utility are also the things that make it controversial. So that then brings us to large corporate restructuring. And as I said, we have had two tools until comparatively recently. And following the Corporate Insolvency and Governance Act 2020, we now have three. So the important point again to note is that until comparatively recently, probably really the beginning of the 2000s, large corporate restructuring in England was an out-of-court affair. And we've talked about why, we've talked about the London approach, we've talked about the changing nature of the financial market and why this shifts. And when it shifts, participants in the market dust down the scheme of arrangement, which had actually been a very popular debt restructuring tool at the end of the 19th century in England, but really falls out of popularity as this out-of-court restructuring supported by London approach principles really comes to dominate the market. And when that loses its force and when it becomes necessary to find a legal tool to try to deal with holdout creditors or disengaged creditors or simply creditors who can't be located, some of these syndicates are now enormous. And as I've said, the debt trades regularly. So it may be extremely difficult for the borrower even to know who its lenders are. And of course, that is an even greater problem in the high yield bond markets. So the participants dusted down the scheme of arrangement. As I said, a great deal of 19th century authority for these as a debt restructuring tool. This is a statutory procedure with very slim legislative provisions in our Companies Act 2006. And it's for achieving a compromise arrangement or arrangement between a company and its shareholders or just its creditors or any class of them, which is sanctioned by the court. There are several stages to the scheme process. First of all, there is what is known as the permission to convene application. So in schemes, creditors are divided into classes for the purposes of voting. And a major problem with the scheme, and one of the reasons why it fell out of fashion, particularly in the post-war period, the post-Second World War period in England, one of the reasons why it fell out of fashion was because the court didn't come to a view originally on whether the company had put creditors into the right classes until right at the end of the process. So there was a risk that you put your deal together, went out to your creditors, asked them to vote on the deal, got to court, said to the court, please sanction our deal, we've now done the deal. And the court said, no, actually, I think you put everyone in the wrong classes, you've got to start all over again. That also meant that because it was unpopular, very little case law emerged telling us how to construct classes. And that was a principal reason why schemes fell out of fashion and why the London approach was really developed in their stead. This was resolved by the courts, which frankly, with pretty little legislative guidance, came out with a practice direction in which they said that there would be an initial hearing known as the permission to convene hearing, at which the court would look solely at the constitution of classes. And so that is now our first hearing. It's followed by the scheme meetings, and I'll talk a little bit more about that in a moment. Assuming that the scheme meetings are successful and that the scheme is approved by the requisite majority, then the company goes back to court and asks the court to sanction the scheme. Assuming the court sanctions the scheme, then that order is delivered to our registrar of companies, and at that point the scheme takes effect. Although, of course, once the judge's gavel comes down and you have your order sanctioning the scheme, you are under an obligation to register it. So how does voting in the scheme work? Well, the scheme has to be approved by a majority in number, representing 75% by value of those present and voting at each scheme meeting before the court has jurisdiction to sanction it. So the astute among you will be wondering why I have referred to each scheme meeting. And the reason for that is because of this obligation to put your creditors into classes. The leading authority on this is Hawke Insurance. And what we do is look at the rights of the creditors. So it's both the rights going into the scheme. Do they get the same interest rate under the debt that's being compromised? Do they have the same maturity date and so on? And also, what is it they're being offered in the scheme? And if those rights are really so dissimilar that they cannot consult together with what the jurisprudence calls their common interest, in other words, could I sensibly vote with you on whether I thought this offer was a good offer? If actually I'm suffering more of a loss than you are because my interest rate is effectively being cut by more. Or if I'm being offered something different from you, then we can't vote together in any sensible way because we're going to have a completely different orientation in how we approach the plan. So if rights are so dissimilar that we can't vote with our common interest, then we will be placed into different classes. And actually, this is the legislation treats them as distinct arrangements. And so each class votes on the deal that it is being offered. And the crucial point in a scheme is that every one of those meetings has to achieve the requisite majority. There is no, what the US lawyers call cross-class cram down, no ability to impose the plan on an entire dissenting class. So I can impose the plan on a minority within a class if 75% by value of those present and voting and a majority in number vote for the plan, then the minority can be forced within that class to accept what they're being offered. But if an entire class votes the plan down, if we don't achieve 75% by value and a majority in number in an entire class, then the scheme fails. And it doesn't even get before the court for sanction. What happens at sanction? Well, the court has to be satisfied that the arrangement is such as an intelligent and honest man acting in respect of his interest might reasonably approve. This is, of course, though, a majority procedure. The fundamental idea that underpins the scheme of arrangement is that if I have invested in common with others, then I shouldn't be able to hold the deal up if I'm in the minority and the majority want it to go through. And so the English court is relatively reluctant to interfere with the majority vote unless they see what is sometimes called a blot on the scheme. That within that majority, it was really directors who had a particular interest who were pushing what would happen. Or within that majority, there were creditors who in fact were invested in a competitor. And that's why they voted for the plan, not because they thought the plan was a good plan. But the starting point is nicely summarised in this quote from English, Scottish and Australian Chartered Bank, that if the creditors are acting on sufficient information and with time to consider what they're about, and they are acting honestly, the judge considers better judges of what is to their commercial advantage than the court can be. So provided you get your 75% vote and your majority in number, you have a very favourable wind behind you in achieving sanction of your scheme of arrangement. Now, I'm not going to go through this rather frightening looking slide in any great detail, but again, the astute among you will have focused on this problem of the lack of a cross-class cram down power. So that if an entire class votes the scheme down, the scheme fails, the court can't even consider it. And this contrasts with other jurisdictions, notably US Chapter 11, that do have a cross-class cram down power. Now, we developed a relatively complex workaround for this, twinning our scheme of arrangement with a pre-packaged administration sale in order to achieve a cram down functionally. So what happens here is that the scheme is used to impose the deal on senior lenders, assuming that the senior lenders are being offered something in the restructuring plan, but they cannot achieve a unanimous consent on their deal. So the scheme here is really limited to the senior lenders. But then what we want to do is strand our junior debt, who we cannot get to agree to the deal. And here I've assumed that the junior debt is mezzanine debt. In other words, I've assumed loan debt ranking behind the senior facility. And so what we do is a version of that connected party prepackaged administration sale, which we've just seen. We establish a NewCo. We probably have to offer management some equity in that NewCo. In large companies in the UK, it has become extremely common to incentivize management by giving them an equity stake. But NewCo is otherwise owned by the senior lenders. So I have assumed here that the senior lenders have done a debt for equity swap. The finance company then sells the shares in the operating parent and the rest of the operating group to NewCo. And there is likely to be some sort of new loan facility which comes into NewCo. Effectively, the consideration for that deal is the release of the senior debt. So the senior debt has been released in exchange for equity in NewCo. NewCo now owns all of the operating group, but you will see that the mezzanine lenders have now been left behind, stranded in the now empty finance company, which no longer owns the shares in any operating business. And so functionally, this achieves a cross-class cram down. This is a complex transaction. It also relies on certain provisions in our intercreditor agreements, which I don't have time to go through today. It was relatively infrequently implemented in reality, but it was frequently developed as a stick to persuade creditors to agree to a scheme of arrangement. So very common for the scheme of arrangement to be plan A, the scheme twinned with a cram down power, twinned with a scheme of arrangement to be plan B, and that plan B to be used as the stick or the threat which persuaded lenders that they may as well agree to what they were being offered in the scheme. And so not infrequently, the junior creditors would be offered something comparatively slim or small in the scheme, but told that if they didn't come along with the party, then the scheme plus prepackaged administration deal would be implemented and they would be left behind and they would get nothing. Similarly, it was relatively frequently threatened as a mechanism for dealing with shareholders. There were not, though, a huge number of these transactions. They are very complex. They rely on the drafting in the intercreditor agreement and the loan agreements working. And there are also quite difficult accounting and tax issues with them. So they were not particularly popular, but very important as a tool to encourage bargaining. So that brings me in the nick of time and with only 2 minutes to our new Part 26A restructuring plan procedure. This is very closely modelled on our scheme of arrangement. Scheme of arrangement is in Part 26 of our Companies Act 2006, and this new restructuring plan procedure has been inserted as Part 26A. So this is it's very closely modelled on a scheme. But the crucial change is that it has explicit provision for cross-class cram down. I'm not going to talk about how that would work today, but the court now has a power at sanction to implement a deal over the objection of an entire dissenting class in the restructuring plan procedure, which they did not have in the scheme plus the scheme in the scheme of arrangement. The other much smaller changes are that there is a threshold condition to using this procedure. So anybody can use a scheme, but to use this procedure, you must be in financial difficulties. There are express provisions who must participate in the restructuring plan procedure, which are more prescriptive. In a scheme, the company is really free to choose who it includes and who it does not. Although it is possible to appear at sanction to object to the fact that you were not included, or to appear at sanction to object to the fact that somebody else wasn't included and you were. And the voting threshold is only the 75%. We have got rid of the majority in number requirement, which caused particular problems in capital structures with bond issues. So some differences, 4 differences really with the scheme of arrangement, but of these, without a doubt, the most significant is our new cross-class cram down power. And we are already seeing, we've had our first restructuring plan procedure in which the cross-class cram down power was invoked. And I suspect we will see many more. So I'm going to stop there for the moment. Let me just stop sharing my screen.
Thank you, Sarah. I know that's a lot of information, but it's been put together and summarized in probably the best manner. So I know there's a lot to take away in terms of how to summarize for a general takeaway from this lecture. But moving towards one of the key aspects that needs discussion and is very relevant to India is the question of prepackaging. And earlier, the first lecture today also looked at prepacks, but the Singapore regime defines prepacks very differently, as opposed to the UK regime, where prepackaging is again a different definition, as we have seen over the course of this lecture. Now, from the Indian perspective, we are looking at prepackaging for small and medium enterprises. However, separating the restructuring from the corporate insolvency process, we still have limitations that are being placed on who can restructure, who can assist in the restructuring of it, and promoters and related parties have been restricted as persons who can be involved in the restructuring process. As of between yesterday and today, we've also seen the Supreme Court in India go a step further and say that this is going to apply to schemes of arrangements as well, making the entire process of restructuring slightly more tight-fisted and very, very difficult as on the view of how pre-packs have been structured in the UK and even in Singapore. So can you talk to us a little bit about the comparative, and are there restrictions? If not, why not? And how enabling are pre-packs in the United Kingdom?
This is a really excellent question, Ishana, and it gets to the core of the controversy in the UK, which I touched on very briefly. So, of course, small and medium-sized family-owned businesses are extremely important in the UK. They're massive employers and they account for a very significant part of our economy. So they're not big employers individually, but collectively they are very significant. And the prepackaged administration, without a doubt, is a pretty effective tool for restructuring those small companies. As I've said, and I have done small company restructuring. You've got the cushions off the armchairs looking for every last cent to pay the costs. Time is of the essence. You've got a very small management team that is extremely stretched. You've often got a small number of really crucial suppliers and customers, and if you lose them, you have no business. And so it's an extremely effective tool because it's quick, it's secret, and it's largely non-negotiated. You just impose it. And so you take all of those costs out of a restructuring process, out of the deal. And that is without a doubt very effective. But of course, therein lies the massive controversy, as you've hinted at. And they are not loved by everyone in the UK. There is a strong, I think, division between insolvency practitioners and insolvency lawyers who see these as a highly effective tool, and creditors who have been on the receiving end of them, who've seen them as thoroughly lacking in legitimacy because they're secret, because they had no idea that it was happening, because they have a sense that the insiders did know that this was being planned, because they think they would not have traded with the company in the shadow of the putative prepackaged administration had they known that this was going to happen. And ministers worry about these a great deal. Our parliament worries about them because they get many, many letters about them. So our MPs get plenty of letters from their constituents complaining about the pre-packs. They are frequently covered in the press as being an illegitimate tool. And often the insolvency community slightly shrugs and says, well, it is what it is. And so underneath all of that, there's a central policy question. To what extent is that legitimacy question so important that actually you should just make these virtually impossible, these connected party prepackaged administration sales, or as you're indicating, put significant restrictions around them? And I think if you do that, you are prioritizing those legitimacy concerns. Or do you take a more pragmatic view that actually this is the only way really effectively to save many of these businesses? And if you require them to do anything that is more transparent and more formalistic, it's likely that they will simply fail. And that really is the central policy dilemma. And what has happened here is that the controversy won't go away, and we consistently have reform efforts. So we have some brand new regulations which are going through at the moment, which will require you to reach out to an independent expert, for the expert to have a view on the price. Is the price that is being paid a fair price? Before that, we had a voluntary system for doing that. We had something called the pre-pack pool, where you could reach out to the pre-pack pool and ask them to say whether they thought the pre-pack looked okay. And they had a red light system. No, it doesn't. Amber, can't really say we haven't got enough information, or green, go ahead. But virtually no one went out to the pre-pack pool in that voluntary system. So now it's being replaced by some mandatory regulation. My own view, for what it's worth, though, is that it will not solve the problem, because the problem here, I think you can layer on as many people after the event saying this deal was okay as you like. If I deal with a company in the shadow of insolvency and I subsequently lose my money, and I have the sense that a group of insiders knew this was going on and I didn't, I'm very skeptical that I will ever be happy with that form of transaction. And so I think it comes down to a straightforward policy choice. It would be, though, I think, a brave government that would outlaw these in the UK completely. And in fact, I'm chairing a panel at a big industry event in a few weeks, at which we'll look at whether we could use the new restructuring plan procedure, which has been conceived of, as I said, as a large corporate restructuring procedure. Could we adapt that with its cross-class cram-down mechanism for small companies? Is there a route through that? Because it is possible that these legitimacy concerns will become so significant that people will be attracted by using other tools. But it would, absent something like that emerging in the market, it would be a pretty brave government that put those sorts of conditions around a pre-pack in the UK, because they are so regularly used, and particularly coming out of the COVID-19 pandemic, when we have so many small companies which will need to deal with pre-lockdown liabilities. But underneath it all, I think it's a policy question.
That's quite fantastic to take away from this, Sarah, because one of the conversations and the themes, underlying themes of all the lectures that we've had, is the politics that is involved in insolvency law or restructuring policy, right? Which brings to the big question, because when India started out and introduced its law on insolvency, there was a big 12 test run that was done, and that included group insolvencies. And with the group insolvency question, raises the question of restructuring and effective restructuring tools, because what is being viewed in terms of data is that the bigger the debt, the more possibility of restructuring, sectoral restructurings and so on and so forth. How has restructuring in group and large corporation cases, as you put it, been utilized in the UK? And just to be a little controversial, I want to talk about the EU-UK relationship in terms of restructuring. And there has been a very, sophisticated solution of let's negotiate a treaty on how we do cross-border restructurings, particularly group restructurings, because you do see a lot of industry across Europe, and UK and EU relations being solid. So that's a two-part question in terms of how does the local law respond to it, and how do you look at restructurings from a cross-border perspective?
This is a really interesting question, Ashana. So first of all, domestically, this may yet be a story of two parts. So from 2008, so from post the financial crisis up until really the beginning of the pandemic, typically what we did was we limited large corporate restructurings to the financial debt. So to the loans, the bonds, and the equity. It was unusual in a large corporate restructuring to seek to compromise trade liabilities. You generally let them, as the Americans would say, ride through. And there is a particularly important mechanism in the UK that enables you to release guarantees and security in the scheme of arrangement of the finance company. So you can put the finance company into a process, and if you are only trying to deal with your loan, bond, and equity debt, you can restructure solely in that company. And you can release any guarantees and security which were given by operating companies in that finance company process. That's been really significant in the UK in the last decade, because it has meant that you can leave the operating companies alone. The message to your trade is, don't worry, you're not even in any sort of process. There's a bit of a row going on up here in the finance company between the financial creditors, but it's got nothing to do with you. And we have not then really had to grapple with putting multiple companies in a group into a process in the way that, for example, you would see in Chapter 11, where you would see vast numbers of filings of companies within a group. Now, of course, that really may change coming out of the COVID-19 pandemic, because the pandemic here makes it much more likely that you will need to compromise trade liabilities. So pre-lockdown supply, where the goods were perishable and you had to throw them away. Leasehold liabilities because you incurred your rent, but you didn't trade and you didn't make any money. And so we may well see that problem of having to put multiple companies within a group into domestic processes and possibly using different tools. So we've already seen that. So what you will have seen from a 50-minute canter through the history of English restructuring law from 1980 to the present day, what you will have seen is we have multiple tools. We don't have a single tool. It's a modular process. You can pick tools, you can put them together, you can use them on their own. It's like I don't know whether you have Meccano, a children's toy in the UK, where you can bolt bits together to build machines. And it's like a big Meccano set. And so we might see different companies going into different processes and using different things to use different liabilities. And I think we will only see that emerge now. That hasn't been a feature of the last decade. In terms of cross-border restructuring, you are of course right. So most European companies have some sort of cross-European, pan-European trade. Actually, even very small companies frequently also have businesses, assets, credit in other European member states. That's not at all unusual. And England has dominated the restructuring of financial liabilities for pan-European groups in the last decade, and has used an extremely complex smorgasbord of European regulations and directives to get comfortable that it both has jurisdiction to do that and that the court should properly exercise its discretion to do that. And of course, that landscape's shifting for two reasons. One is, of course, Brexit, which you will all be aware of, so that we are no longer party to some of those regulations and directives. And secondly, that many European member states are bringing in their own restructuring procedures. And so actually all of Europe at the moment is grappling with the question of how you restrict the opening of multiple procedures across Europe. And that's actually not just in flux from a UK-Europe perspective, it's also in flux within Europe, because the primary European regulation is not very well adapted for financial restructuring. And so many jurisdictions don't want to fall within that when they're doing a financial restructuring. So that's a really complicated, separate story, which is significantly in flux at the moment and is complicated by some other European regulations, which jurisdictions who are not actually member states are still susceptible to. This is a really, really complex and hugely fascinating moment in time. And I think what we will see actually is a pan-European effort to try and work this out, to try and work out how we restrict the opening of multiple procedures. We're at a moment where we could go one of two ways. It could become much more common in Europe to have multiple parallel procedures in different European member states and in the UK, or we may find a new way of restricting that multiplication of procedures. And the jury is slightly out on that at the moment, I think.
That's a fantastic kind of wrap, because one of the conversations has always been, why can't judges just pick up the phone and talk to each other and sort it out and not initiate proceedings, versus why can't countries just talk to each other, and it is not just a question of whether it is common law and the courts have more power versus civil procedure. It is just a question of country to country communication and globalization being the same. So that's a huge takeaway, and lots to see in India, particularly in restructuring and insolvency upcoming and as we speak. So thank you for this excellent insight, Sarah. I am mindful of time, but this is an excellent wrap to the first set of lectures on insolvency law and lessons from other jurisdictions, because oftentimes restructuring in India has been used in a manner where there is excessive regulation or it is just entirely creditor driven. And it's interesting to learn how other jurisdictions apply different strategies for different kinds of business requirements as well. So that is a huge takeaway. I want to thank our audience, and I want to thank you very much. We're going to do a repeat of this every semester, I think, and that's what I'm going to say every year. And hopefully next time you're going to be at the university, as you can see in the background.
And that would be lovely.
With that, I want to say thank you and sign off for this lecture series. And I hope that the audience will join us for the rest of the week as well in the lecture sets that we have planned. Thank you, Sarah. Thank you for your time. Have a good day. See you soon, everybody.
Thank you, everyone.